Madam Chairman, to my friends, I say, with all due respect, and I mean that, we have a history of a half a century of fighting and litigation over public lands, management of public lands, and particularly in the timber industry and the national forests and on the BLM. This started 50 years ago as an antagonistic, combative system with the people drawing lines on both sides and nobody giving quarter. Over that period of time, cooler minds have prevailed, and we've gotten to a point where, for instance, in Idaho, and I know this is true in Montana and Wyoming, we manage a lot of the forest lands by a collaborative process. And a collaborative process is a process by which the parties sit around the table, and it is parties across the spectrum, whether it's industry people harvesting, whether it's motorized users or conservation groups that want to protect certain areas. And we've had a really good success in this collaborative process. I mean, really good success. It's eliminated a lot of litigation, and it's been a give and take, and the parties come away from the table with a lot better feeling and a result. I had personal experience with this when I was governor. We got a roadless rule. Idaho is the only state, with all due respect to Colorado, we've got the only significant and substantial roadless rule that was written by us and written through a collaborative process.
Senator, does anything prevent you all from doing what you just said has been working for you?
No, well, this is at the end of the day, when the parties all shake hands and walk away from the table, what happens is the fringe groups, as Senator Daines indicated, who refused to sit down at the table, and that happened to me in the roadless rule, they then go ahead and file suit. And what they do is they forum shop, which you can't do with a alternative dispute resolution. Sure. And so this is really de minimis. I mean, we're talking 2 projects out of thousands every year. So, this is not intended to be a run at environmentalists or anything like that. What it is designed to do is to do what most industries, what most people in America are moving towards, and that is arbitration as opposed to litigation. Gotcha. Because the litigation goes on for years and years and years, and you have various steps through the appellate process.
Can I ask just because you all, Senator, if I may?
No, I'll yield to the.
I just want to ask the question because you two would know. From those of us that aren't from BLM states, parts of the country, we don't really understand it that well, except that the federal government is much more involved in your land than they are in our land in West Virginia.
You're a lucky man.
When you have professionals that are saying that this is a hazard of forest fires that could cause absolutely unbelievable damage, is there, then you're saying no matter what, you have people that are going to protest that. They don't want you to cut under any conditions whatsoever.
It happens every day.
Even when there's, now they.
Absolutely right, Senator Manchin. Yeah. This is the frustration at the moment on the ground across the counties in Montana is at.
And all professionals agree this needs to be some cutting to cut down the fuel.
I just want to make sure that we're able to record all this. So
we're actually deliberating in the Senate. This is a good thing.
And this is a fine
We don't
thing.
do this much.
We don't do it very often. Yeah, stop
like
it right now.
I like it.
Yeah. So,
Senator Daines.
Thank you, Chairman Murkowski. We put some strict parameters around this to try something out. What we're having here is this has to be collaboratives. Collaboratives will have conservation groups, local county officials, wood product groups. It's a diverse mix of folks that come together that oftentimes takes years to say we're going to do this project, and it starts to move forward. In this case, we have one environmental group that litigates virtually every one of these projects, and they get tied up in court for years.
Same group?
Yes, sir. The same group. And so it's an abuse of a process right now. And so, and back to this take it or leave it, it's not baseball-style arbitration. We work with the Forest Service to say, take it, leave it, or another option is the arbitrator can say, you guys got to go back and come up with a better plan. Literally, work this out.
That's not with the bill.
That's in here. We changed that. That's
you did change that.
Yeah, that's the technical correction. We work with the Forest Service here to make some technical. That's why the Forest Service just yesterday came in and says, we support this bill.
My concern is only this, Senator, is that if there's a professional, people of good standing, professional credibility are saying, I just think this is basically a commercial move and it's not really an environmental move. It's not really a protective move. Is there some protection there for they can go back to arbitrate or go back to basically court decision, if you will, litigation.
So the arbitrator can remand it back to,
Chair.
and say, that's the third option. So it's binding, but they can remand it back and say.
That's what you changed in.
Exactly.
Okay.
I'm going to turn to
We have that third
Senator,
option, yeah, thank you.
Senator
Can I
Cantwell here.
can I reclaim my time?
I don't know who
Grab it
had,
while you can.
who had time here, Senator Risch. I would like to wrap
Mm-hmm.
the conversation. It is important, though, because I think it speaks to the reality that those of us in the West face. And it's important that our colleagues that come from states that don't have significant portions of their land held by the government.
And Ranking
So
Member- yeah,
it is an
and-
important discussion.
There's 28 projects right now in litigation in Montana. We're saying 2 projects across 3 states per year for 5 years. So 26 can continue to move through the court system. We're just asking, can we try something different here? Maybe and get a better outcome. That's what we're asking for
Madam
here.
Chair,
go to Senator Kemp.
ask counsel on this? So this creates a standard of arbitration within the Forest Service. So there is no further court process. These arbitrators would make these decisions.
That's right, Senator Cantwell. To follow up on Senator Manchin's point, this is mandatory arbitration. We have a lot of experience in this country with arbitration, going back to the Federal Arbitration Act of 1925. It is always provided for consensus between the parties. Parties have to agree whether they want to submit their case to binding arbitration. The Administrative Disputes Resolution Act of 1990-something, same way, requires the parties to agree. This gives environmentalists or other people challenging a Forest Service decision no say in the matter. The Forest Service, and I appreciate Senator Daines' efforts to try to limit the number of these projects that would be subject to arbitration, but there again, that leads to greater unfairness. The Forest Service decides which projects it wants to protect from judicial review, and the litigants have no say in the matter. Arbitration has typically been used to resolve factual disputes, matters of contract or matters of employment. Many of these Forest Service cases involve fundamental legal issues. Is the Forest Service complying with NEPA? Is it complying with the Endangered Species Act? Is it complying with Healthy Forests? Is it complying with the Administrative Procedure Act? Those are legal determinations rather than factual determinations. This bill does not even require arbitrators to be lawyers. And the worst matter, which gets to Senator Cantwell's point, there is no recourse to the courts to have a judge reverse the arbitrator's decision for legal error. Basically, the court can only reverse an arbitrator for malfeasance by the arbitrator, not for fundamental legal error as to whether the Forest Service is complying with law. So there's ultimately a fundamental due process question involved here. The Administrative Procedure Act very clearly states that any person suffering a legal wrong because of agency action should be entitled to judicial review thereof. And this basically says the Forest Service can determine which individuals it's not going to allow recourse to the courts.
Yeah, Madam Chair, I got to respond. I got to respond to that.
We can't leave that.
That's not accurate. That's
Can't
not
leave
accurate.
that
The bill says.
Senator Daines, I'm gonna let Senator Risch reclaim his time, and then we'll go to you.
And I'll yield to Senator Daines. But Mr. Fowler, with all due respect, the matters that are submitted to arbitration are not necessarily just factual questions. Frequently, there are legal questions that are submitted to arbitrators. Your statement in that regard is simply inaccurate. It is widespread throughout America today. It's contained in contracts. It's contained in statutory language. And with all due respect, I wish you would sit on one of those collaborative boards one time and see the frustration of this group of people who come at it from all sides and reach an agreement, and then you have a fringe group that takes it through the courts and is financially incentivized to do that, because if they find one dinky flaw in that, they get hundreds of thousands in attorney's fees under the whatever that act is that we have. So with all due respect, Mr. Fowler, what we're trying to do is we are trying to, in a very, very limited fashion, get these matters resolved after they've been through a system that has the deepest due process you've ever seen with these people around at the table. So with all due respect, you are dead wrong on this. Thank you, Madam Chair.
Senator Daines?
Just